Let me, in the presence of the jury, state one thing. There was a question when I was meeting with the jury just to advise them of what was about to happen as far as our procedure goes. There was no discussion of the case, but one of the jurors asked if there was a possibility of asking about a definition of a medical term, and I advised them that that would not be possible for me to give any definitions of medical terms because it would be based upon the evidence, and the evidence is closed, and therefore any definition of a medical term, ladies and gentlemen, would have to be based upon what you heard in the way of evidence. Now, before we begin the closing arguments, I would like to advise you of this fact. The state and the defense in this case have entered into a stipulation, and I think we had one earlier perhaps, but a stipulation means that the parties are stipulating this fact to be true. The state has submitted proof at a sentencing through the testimony of Deputy Joseph Calhoun, regarding 2 tattoos on the body of the defendant. The one tattoo on the upper back of the defendant, which says, "Crush your enemies, show no mercy," was present on the defendant when he was taken into custody for these offenses. And this stipulation is announced in open court on today's date and is memorialized in a written stipulation which will be made an exhibit to this record. That is the only stipulation that I have to present. So at this point now, the state will have the opportunity to make its initial closing argument to you regarding the punishment phase. General.
Good morning, ladies and gentlemen. I just want to take a brief moment to, again, thank you for your patience throughout the last 2 weeks. This is a lengthy process and one that I know has worn on you, as it has everyone gathered in this room today, and we can appreciate your service, and we do. I'm going to keep this very brief. The state, as you will see in the instructions from the judge, is arguing 5 aggravating factors in this case. 5 factors which we are asking you to consider, as we are also asking you to consider sentencing the defendant to death. Those factors, beginning with number 1, that the defendant was previously convicted of a crime other than the one he's presently charged with that involved statutory elements of use of violence to a person. That's the first factor that we're asking you to consider. This particular factor, if you recall from the proof in the case, was testified to by an assistant district attorney in Williamson County. And as exhibits, you will see the transcript and the judgment in this case of aggravated assault that the defendant was convicted of. And it involved bodily harm as he held a knife, as you can see from the transcript, to Tiffany Beach. That's the first factor, and we submit to you that this is proof beyond a reasonable doubt that this factor has been proven. Factor number 2, that the murder was especially heinous, cruel, in that it involved serious physical abuse above that which is necessary to produce death. The evidence in this case to support factor number 2 begins when Sergeant Daniel Baker, on his body camera, shouts the words, "Shots fired, officer down." At that point in time, Sergeant Baker knew that he had been shot while standing on the passenger side of the vehicle. He knew he was going down, and he ran away from the car. As you have seen and heard from the body camera, his last few breaths were occurring as the defendant walked up and shot him in the head. This factor we're asking you to consider in that the defendant used more violence than was necessary to produce his death. The next factor, the murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant. As we see on the screen, the defendant, and as the proof was provided to you in court, on May 30th of 2018, the defendant had 5 active warrants. 5. From different times. 3 warrants from the previous day. 2 additional warrants, one from Dixon County and one from Williamson County. 5 active warrants. This murder was committed because the defendant was trying to avoid being arrested. We've taken clips from the defendant's interview, which you have seen, the interview with Nathan Neese, and I'll point to the first clip.
Dixon County went to my house on Yellow Creek Road looking for me. That's why everything was packed up and was leaving the state. I was going to run out of state.
Where were you going to go?
I ain't really decided yet. Kentucky, Illinois, New Mexico, California, somewhere.
From the defendant's own words, you can hear that he knew law enforcement was looking for him because he had active warrants. They had already been to his house on Yellow Creek. And as he says, that's why he was packed up and attempting to leave the state. Because he didn't want to be arrested, ladies and gentlemen. He was trying to avoid being arrested. And that's what led and caused the murder of Sergeant Daniel Baker.
Why would you give an officer that you say you're being cooperative with a fake name or a different name and a bad social security number?
I don't have a driver's license.
Why would you give an officer a fake name? He said, because I don't have a driver's license.
Okay, so that's another kind of interesting statement. What's a cooperative guy with law enforcement say that if he just could have got the door off open, he would have just run? Why'd you not want him to know who you were?
I don't have a driver's license.
That's it? I'm just gonna be blunt. Kill the guy over not having a driver's license?
I got a bunch of violations against me on
How much pay were you?
$5, 10, and 3.
18?
And they're all consecutive.
Ladies and gentlemen, this is a summary of this factor. The defendant says it in his own words. When Agent Neese says, let me get this straight. Why would you kill a man just for not having a driver's license? Well, he killed him because he had active warrants for him, because he was on the run. Because he knew, as he said right then, he had multiple violations. These active warrants waiting for him. That's why he concealed his identity. He didn't want to be arrested. He was trying to leave the state, as you heard in 2 clips prior. He killed him. He killed Sergeant Baker to avoid being arrested.
You told her what now?
I said, I love you. I'm sorry, baby. I'm going to jail.
Why did you say you were going to jail?
Because I know I got 2 active warrants on me.
Is that when you... So, is that about the time he gets to the window?
I told her, I mean, that's all. I swear to God, I told her, baby, I'm going to jail. I love you.
And she said...
And she said, but you're going? I said, I'm going to jail. I love you. I said, She says, I'll be here for you.
As he tells this agent, I knew I had 2 active warrants for you. I knew it. There is, ladies and gentlemen, there is no doubt the defendant killed Sergeant Baker because he had active warrants. He was trying to avoid law enforcement. He didn't. Just that simple. It really is. The 4th factor. The murder was committed against any law enforcement officer who was engaged in the performance of his official duties, and the defendant knew or reasonably should have known that the victim was a law enforcement officer engaged in the performance of his official duties. And ladies and gentlemen, I think this factor has been proven beyond all doubt in the evidence, but just to recap, Officer Baker, Sergeant Baker, was wearing a uniform, was driving a marked patrol vehicle, Vehicle 500. He was dispatched to the intersection of Tidwell Switch Road and San Vineyard Road. He arrived and he asked for the defendant's ID, wearing his uniform, following procedure.
One of the questions I had, when he walked up to the car, you knew and identified him as a police officer, is that correct?
Yes, I know he was an officer.
When Sergeant Baker walked up to the car, it's the question that Agent Neese asked of the defendant. You knew he was a police officer. And his answer was yes. And it's obvious. He was wearing a uniform. He arrived in a patrol unit. The defendant acknowledges on tape he knew he was a police officer.
Okay. So one of the questions I had, when he walked up to the car, you knew and identified him as a police officer, is that correct?
Yes, I know he was an officer. Begin with, he walked up and he asked what was going on. I told him we had a flat tire. I had a friend on the way. And he was like, okay. And then he started just...
Did he ask you for any ID?
He asked me for my ID. And I told him I wasn't sure exactly where mine was because the car was packed to move.
Okay.
You know, I mean, everything, it was... And he was like, okay, and he asked my wife her name and so and she's like,
Performing his official duties. It's common sense. What does a law enforcement officer performing his duties do when he approaches a vehicle? He asks for IDs of those inside. And you can hear the defendant say, that's what Sergeant Baker did. He asks, what's going on? The defendant says, I've got a flat tire, and Sergeant Baker, in performance of his official duties, asked for their identification. Now, we all know that the defendant lied about his ID. He gave a fake name and fake social security number. But there's no doubt that Sergeant Baker was performing his official duties.
So he asked you who you were, right? When he walked up, you knew he was a cop, and he was asking you who you were. Who'd you tell him you were?
I told him I was Scott Wiggins.
And what social security number did you give him?
Just one off the top of my head.
Just numbers off the top of your head? Is it close to yours?
Yeah.
What?
I told him I was Scott Wiggins. And I gave him a social security number off the top of my head. That's what happened when Sergeant Baker, in performance of his official duties, approached the defendant. That's what initially happened. And ladies and gentlemen, the fifth and final aggravating factor that the state argues we have proven in the course of this sentencing hearing is that the defendant knowingly mutilated the body of Sergeant Baker. And I'm not going to show you a graphic photo here. I just want to show you one statement from the autopsy report and the testimony of Dr. Lee, which you've already heard. Thermal injuries. 10% of the total surface area on the right flank, right chest, right abdomen, right hip, right buttock, right side of the back, and right upper arm with second-degree to third-degree thermal injuries. There is no evidence of soot material in the airways. And I want to repeat that last part. There's no evidence of soot materials in the airways. Here's why that's important. Because these injuries occurred, these thermal injuries, these second and third-degree burns occurred after Sergeant Baker was killed. And that's the mutilation of the body. 10% of the body. Second and third-degree burns. But why is the statement, no soot in the airways, so important? Because of the testimony from Dr. Lee. Once the fire was started, had Sergeant Baker still been alive, Dr. Lee said there would have been soot in the airways. And there was no soot in his airways, which means that Sergeant Baker was dead when this fire was started. The defendant started this fire in an effort to destroy evidence and flee the scene. And in doing so, he mutilated the body of Sergeant Baker. These are the 5 aggravating circumstances that we are asking you to consider and that we are arguing that you should use when considering the punishment of death. Thank you.